Welcome everyone to the second committee meeting on temporary rules. I know it's been a while, so hopefully everybody remembers what we talked about last time, and we're excited to get started again. So I'm going to start, as I always do, with the roll call. I'm going to call two rolls. The first will be the names of committee members and their alternates. After each name is called, the person should say here so we can make sure their mics are working. The second roll will be the names of ACUS members who are not on the committee and their alternates. After each name is called, the person should say here so we can make sure their mics are working. I will not call the names of members of the public who do not have speaking privileges. So starting with committee members. I see Jen Dickey, our committee chair.
Here.
Right. Do we have Laura Barheit? No. Tyler Badgley? How about Brigham Bowen? I'll keep going down the list. Amy Bunk?
Here.
Great. Looks like I think Seth Davis is going to be here, but he's going to be a little bit late, so I won't call on him. Stephanie Davis, I saw.
Here.
Thanks. Carolyn Dubé?
Here.
Great. Do we have Matt Lawrence? Actually, I think he might be joining late as well, so we'll defer on him. Let's see who else. You know what? Let me just do one thing real quick. All right, do we have Dale Murad, alternate for Elena Ness?
Yes.
Great. Do we have Mitch Plave? Okay. How about Lon Smith?
Here.
Great. And with David Zaring is going to join.
I'm here now.
Yep. Great. Awesome. And you can just stay here for the first 30 minutes, right?
Yeah, I'm
Okay,
unfortunately.
all right. Thanks for joining us.
Yeah.
Are there any committee members who I did not call?
Yes, Bill Funk.
Oh, yeah, Bill. Thanks, Bill.
Alex, good enough.
Oh, Alex, great. Any other rulemaking committee members?
I'm not positive. Is Dan Cohen a member of this particular committee? Because sometimes I serve as his designated alternate. Devin Frey.
Yeah, he's not a member of the committee, but I got
one.
you down as an alternate.
Okay, great. Jen Kelly Kennedy is here in his stead, but she's running a few minutes late, so I'm taking notes on her behalf.
Okay, great.
Okay.
Thanks. Any other committee members? Last call.
Is Helen Serasio a member of the committee?
No, she's not.
Didn't think so. Okay, thank you.
All right. Thanks, Noel. All right, we'll move on to ACUS members or their alternates who are not on the committee. And so I got Devin and then possibly Jennifer as alternates for Dan Cohen. Jeff Lubbers.
Here.
Great. Do we have Christina Greer or Bob Hinchman alternates for Nicholas Schilling? Nope. Tom Johnson.
I'm here.
Great. I saw Jim Tozy.
Here.
Great. Steph Tatham.
Here. And I'm
Awesome.
sorry that I have to drop for a bit at 1:30. I'll try and make it back though.
All right, thanks for letting us know. Are there any ACUS members or alternates that are not on the committee whose names I didn't call?
Hi, this is Kirti Datla.
Hey, Kirti.
Hi, this is Rebecca Orban, sitting in for Elizabeth McFadden.
Okay, great. Oh, and then you're on the committee, so I'm sorry I missed you. Yeah, we talked yesterday. Any other ACUS members or alternates whose names I didn't call that are not on the committee? All right, great. With that, I'll turn it over to Jen.
Hello. I hope everyone had a good Thanksgiving. I'm pleased to get started today. So just going over the standard meeting protocols, please note that only ACUS members, which includes government members, public members, senior fellows, liaison representatives, and special counsels, whether or not on the committee, and their designated alternates have full speaking privileges. To avoid background noise, I'd ask that you keep your microphone on mute and either use Zoom's hand raise feature or add a comment in the chat feature if you'd like to speak. I'll then call on you and you can unmute yourself. Please then remute yourself when you're done. I'd also ask that ACUS members and their designated alternates use the webcam to facilitate conversation. With respect to attendees other than ACUS members and alternates, participation requires the unanimous consent of the committee members. Time permitting, I'll consider calling on such attendees at appropriate points, and will presume that committee members consent absent their raising an objection. If any such participant would like to speak, please so indicate in the chat feature or by using Zoom's hand raise feature and wait to speak until I call on you. You can then unmute yourself and please remute yourself when you're done speaking. I understand we've received one advanced written comment from a non-member attendee, and my plan is to call on them to discuss their comment after we have addressed comments from ACUS members. For all participants, please use the chat feature only to indicate that you'd like to speak, or for committee members and their alternates to vote when asked. Please do not hold any sidebar discussions or put substantive comments in the chat feature. Only members of the Committee on Rulemaking, including government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsels have a vote. Please do not vote unless you're a member of the committee. We have a list of committee members in case you're unsure. With that, I'd ask Ben to go ahead and put the draft recommendation up for everyone to see. And although I know it has been some time since we began consideration of this rulemaking, I do want to pick up where we left off. I know we've received some comments from Stephanie Davis that go back over things we had already kind of passed through, but I wanted to start where we left off because I know there were a number of members of the committee who had concerns about some of these later paragraphs, and we didn't get there. And I just want to make sure that they are given the opportunity to make those comments at the beginning of the meeting, and then we can go back. So let's pick up with paragraph 10, I believe.
Can everybody see the text okay? All right.
I can.
Good.
Okay, so here we have a comment from Senior Fellow Michael Hertz. I'm not sure this paragraph adds anything. An extension of an expiration date is an amendment to the rule. Therefore, Section 553 applies. The paragraph just says, do what 553 requires, unless there's an exception, in which case, do what you always should do when there's an exception. I don't know if Michael Hertz is on, but if not, I would ask if anyone shares his concern and suggests that we delete this paragraph or wants to speak in favor of keeping this paragraph. Hearing nothing, I think my instinct is to just keep it if there's not a substantive objection to it, even if it's not adding anything. IL?
Yeah, just to clarify maybe why we had this paragraph to begin with. Part of the research showed that sometimes agencies are not aware that an extension of a rule is necessarily independent temporary to another temporary rule, basically. So it's to make sure that when an agency wants to have an extension to a temporary rule, they understand the need to go through the process again. So that is that clarification.
Okay. So I would propose we keep it because that makes sense to me. It doesn't sound like he has an objection to the content necessarily. So I would just resolve that comment unless anyone has any objections. And then we'd go to his second comment on this paragraph, which is he has concerns about the word should in line 140, what is now line 147, because he thinks A, B, C are either required, in which case it's too mild, or they can be skipped, in which case it's too strong. Does anyone wish to join in this comment from Senior Fellow Michael Hertz? To me, the should is just like, this is what agencies should do, which is they should follow the law. Jeff Lubbers.
You could say must.
Right. My concern is that Must would depend on whether there's an exception, and that gets to the second sentence. So like, to me, should is kind of
Must,
safer.
must,
Bill, I
must,
see you have a
must
comment.
normally.
Bill Funk.
Yes, I would suggest sort of changing the language in the paragraph to start off by saying the extension of a temporary rule is a separate rulemaking, which, absent an exception, requires publishing a notice of proposed rulemaking, explaining in the notice, inviting public comment, and then you have if the agency for good cause finds, etc. Is a separate, I would say, is a separate rulemaking.
Yeah, Bill, do you want me to, could you keep going? Just to repeat what you said. I got the idea, but just want to make
The
sure.
extension of a temporary rule is a separate rulemaking. Absent, absent exception. Comma. Requiring. And then you go to strike what all the way down to A. And then you make requiring the publication instead of, but after the A.
Or you could just say requiring an agency to.
Okay, that's good. That's fine. Require an agency to before the A.
It's not really a recommendation.
That gets back to the basic point that Michael was making on the paragraph generally, which unfortunately I had to get off the Zoom at that meeting because I had a incoming call on something important. But I sort of one could just delete the paragraph, but in order to get over the problem of should, because it isn't just a should, it is a shall, absent an exception. And then I agree with Jeff, then it isn't really a recommendation. It's just a statement of what the thing is. Except the second sentence is a recommendation.
It's a preamble.
I don't know. I think it's fine. I mean, the second sentence is a recommendation, but it builds off of the first sentence, which says, well, this is what you have to do, and this is what you should do. Anyway, I think my language solves the problem of should. Whether one wants to get rid of the paragraph altogether is another question. I'm happy with it.
I'm fine with this addition. Does anyone have any objections to Bill's rewrite there to address the should issue? Hearing none, let's move to the next comment. Yes, Noelle?
Hi, sorry. I think someone was making the point that this is a recommendation. So to the extent that you all want to refer to where this is actually required, perhaps including a citation to the APA, which requires those things to be included in an NPRM. And if you're going to cite to the APA, I would just note with one caveat, which is that the APA doesn't require the NPRM to state why the agency is doing what it's doing. That requirement applies to the final rule. So with that sort of caveat that it would change sort of the list of things that are required in the APA. But if the intent is to capture what the legal requirement is, as opposed to have the recommendation require these things, then that's the way to do that, I think.
Okay. I'm fine with adding a cite to the APA. I think that's sensible. Hearing no other comments on it, let's move to the comment from Liaison Representative Stephanie Davis of noting it should follow the practices for obtaining public input on the rule identified in recommendation 2024-6. She said that this would improve clarity, although obviously the title of the recommendation gives some input, but I think that it does improve clarity to add that language. So I have no concerns with adding it. Does anyone have any objections to adding Stephanie's proposed language? Okay, let's go ahead and mark that resolved and add that. Moving on to what is now paragraph 11. And we have a comment from Senior Fellow Michael Hertz. How does the agency come to anticipate the need to extend without already assessing the rule? Is it sort of an environmental assessment versus EIS idea? Not sure this really adds anything. Ayal, did you have any comment about the purpose of the paragraph?
Yes, according to our research, some agencies have procedures in place to assess whether a temporary rule should be, if they anticipate that it's not just for a limited period of time, but it's some sort of a pilot or a retrospective review and some sort of a process of regulatory implementation, for example, that they would have a process to make sure that they review the rule and understand whether they want to extend it, to make it permanent or not, before the rule is expired, to avoid the complications that could be involved with how it appears in the CFR, etc. So the recommendation basically says to make sure that an agency build that timeline in advance, so it won't be surprised or we need to rush at the end of the timeline of the expiration date when the expiration date hits. That's common best practice. Nothing more than that.
Bill, I see you have a comment.
Yeah, I didn't really agree with Michael's comment here, but it might be responsive to it if you changed when to if. If an agency anticipates it may need to extend a temporary rule or make it permanent, should it apply. I think Michael's concern was that this was suggesting that an agency should undertake some sort of process for determining whether or not there would be a need. And I don't think that's what this was suggesting. I think it was just saying when or if you anticipate you need to extend it, then you should develop a timeline and sufficient before it expires. So I suggest putting if in there as a sort of helpful change.
That seems sensible to me. Any objections? Looks like there's some support for that. If so, we'll go ahead and make that change, and the rest of the change language in that paragraph about sufficiently before the rule expires also strikes me as good clarity. Any objections to that? Oh, sorry, this is a comment this is responsive to a comment from Jeff Lubbers. That this language ensures that the agency doesn't wait till just the last minute. And that this language seems like a good addition to me. Anyone have any objections or wish to discuss? Hearing none, let's move to paragraph 12. Okay. The first comment was a proposal to delete the words that it issues. That seems like a good clarification. Any objections to deleting that it issues? No? Okay, let's go ahead and delete that. Turning to paragraph 12A. Comment from Liaison Representative Stephanie Davis. It would be more consistent with the section document overall to say circumstances in which it may be appropriate for the agency to issue a temporary rule.
I would say this is probably
I think that does seem.
We kind of addressed this kind of expiration date issue kind of globally pursuant to discussion at the last committee meeting. So just want to note that.
Yeah, this reminds me of like the first comment we had on the rule, or one of the first ones. So I think that's a good edit, and we can just accept that language unless anyone has any objections that they wish to raise. All right. Paragraph D, procedures for submitting a temporary rule to OFR for publication, that the internal policy of an agency on temporary rules should include procedures. And Stephanie says, what is paragraph D intended to address? OFR already has detailed procedures for submitting rules for publication, and for that matter, drafting. So were the drafters thinking about an internal agency process for submitting temporary rules? And if that's the case, shouldn't it be folded into paragraph A or E? Ayal, do you want to have a comment first on why this was in it?
I think the reason that we added it here is to make sure that the agency officials have in their agency guidance have some understanding of how the process looks from the perspective of OFR. Most of the things are written in the handbook, but some of them are not. And I think that having procedures in the agency guidance document makes it clear for the staff in the regulation office or the equivalent, and to make sure that they are submitting the temporary rules appropriately, to make sure that they follow the instructions the OFR wants them to have in order to process the rule correctly.
Okay, and David's staring. I think I saw your hand go up first.
Yeah. This is my first meeting on the committee, so I was a little worried that in general this paragraph would be burdensome for agencies, and so I guess I thought, but I wasn't exactly sure how to amend it. But I guess I thought I'd just say that I agree that the subparagraph D seems to be unnecessary, given that those procedures already exist, and I would like to minimize the number of sort of internal documents that an agency has to produce to bring itself into compliance with our recommendations.
Bill Funk.
Well, I'm afraid I'm going to have to disagree with David. But I'd say to Stephanie, the paragraph begins, an agency should develop an internal policy. So all A through G are all internal policies. They don't apply to anything outside. And so it's not the procedures by which you go to the Federal Register people. It's the internal procedures. So I think that addresses Stephanie's concern to a certain extent. And David, I mean, I'm sympathetic to the idea of having, minimizing difficulties for the agency. However, D is really different from all the other provisions. This is saying you really ought to focus on how you're going to submit this internally, all right? How you're going to go about complying with this OFR's procedures. And that's different from the procedures for drafting or the procedures for getting in public input. It's really a different idea. So I don't think it's a big deal. In other words, of all of these, I think this is probably the least burdensome to the agency. So I really think it ought to stay in.
Stephanie?
No, thank you, Bill. I appreciate your comments, and I agree. And clearly, I need to ask the elves to craft me some reading comprehension this year. I did see internal policy and recognize that. So I agree. I agree with all of what Bill just said, and am happy to stand down from my comment.
And I appreciate the Christmas spirit, Stephanie, with the hat. Ayal?
Yeah, I just wanted to add that this is based on an example of, if I remember correctly, the Coast Guard guidance on temporary rulemaking. And the Coast Guard, as I elaborated in my report, is one of the more heavy users of temporary rules in their rulemaking policy, and they have it in their guidance. And in my impression, speaking with the representatives, that was very helpful for them. So this is the reason we added here. We have a specific example of agency guidance document that uses that and that it helps them. And as I think Bill mentioned, it's not so burdensome when it's the other agency policy. So just for the committee consideration.
Rebecca?
Thank you. Yeah, to Bill's point, I wonder why the procedures would be different for this kind of rule than any other kind of rule. It seems like internally, wouldn't it follow the same process? Are we expecting them to have a separate chapter or line on how to submit temporary rules and how to process them internally?
You want me to respond to that?
Bill, did you want to respond?
I think as other parts of the recommendation indicate, there are special things you have to do with the Office of Federal Register. And that to a large extent is governed by their procedures that are provided to the agency. But I think because those are different requirements for temporary rules and for normal rules, that the idea that procedures internally about how you're going to do it with this Federal Register is a good idea. In other words, it's a different procedure for temporary rules. So I think calling it out is worthwhile.
I'm sorry, I don't want to belabor this point at all. Are we talking about internal procedure for moving a document, or are we talking about how the document's formatted and written for the OFR? Or does it not matter? Do you think that this would cover both?
I think it would cover both.
Okay, thanks.
Okay, so it sounds like Stephanie is satisfied. And so absent, you know, a suggestion from a committee member or someone with speaking privileges who wants to propose a different language to that, I think we can move on to the next comment. Sorry, David Zarin.
That's fine with me. I just wanted to raise that issue, so that's fine.
Okay, great. Paragraph 13. Here we have, I think we have 2 comments here, potentially. Yes, so one is an edit from Jeff Lubbers. And then just like with track changes, I think that the part that changing it from the rulemaking authority available to a specific agency to address emergencies to a specific agency's emergency rulemaking authority. And then a comment from Stephanie Davis that says determines doesn't seem like the correct word, perhaps grants an agency emergency rulemaking authority or authorizes an agency to engage in emergency rulemaking is more accurate. And we have a comment from Bill Funk.
Well, my comment is I didn't know what this sentence was saying, at least this clause, right? Are we saying that when Congress specifically requires, authorizes, permits an agency to use emergency rulemaking authority? Is that what the idea here is, when the Congress specifically provides it as opposed to the generic ability under the APA?
Yes, that's how I read this, that this was, you know, if Congress is going to specifically act on emergency rulemaking authority, it should consider whether it would be beneficial to specifically authorize.
Well, then I would suggest language that would say when Congress specifically provides for an agency's emergency rulemaking authority.
That would address, I think, Stephanie's comment.
Specifically provides for an agency's emergency rulemaking authority. Emergency rulemaking authority, yeah. Comma, and then it picks up.
Okay. Stephanie, does that address your concern about the word determines?
Yes, it does, because I mean Congress grants rather than simply identifying. So I think, yeah, that would address my comment.
Okay. Do you want to go ahead and pop that language in there? Then? And then I think we delete the part that Jeff added.
I'm fine with that.
Jeff's fine with that. Okay. Anyone have any objections to that edit? Hearing none, I think we've resolved 2 comments on that paragraph. And I think that allows us to move back up to the top of the recommendation to some additional edits that were provided, I think, by Stephanie Davis since our last meeting.
You want to go back up to paragraph 1?
Yes.
Okay.
Okay. I see the comment that they've changed temporary rules, so that seems great. Oh, it was from Steph Tatham.
Yeah, hi.
Terminate issue. Yes.
Yep,
Hi,
thanks so
Steph. You
much.
wanna mention your comment here?
Oh, go ahead. Happy to do it or happy for you to do it, either way.
Okay, so her first comment is it should say determining whether and when to issue a temporary rule, which seems more consistent with what we're talking about because we do include some sort of pros and cons of introducing one. That seems fine to me. Did anyone have any concerns with saying determining whether and when to issue a temporary rule?
If we had paragraph 1.
I did intend for them to go together because I think
Okay.
one is where we get into, whether or not to do it. Otherwise, it's just after the agency has made a determination. And so I think it really doesn't have the whether unless we put the whether into it. And I'll just take a step back to say that part of why I suggested the whether is because I think that the committee staff and the consultant did a great job in the preamble of raising the fact that there are some benefits and costs to temporary rulemaking. And so I wanted to acknowledge that as well in the recommendation. And I'm not tied to this language. I know benefits and costs can be touchy words, but I was just paralleling what we saw in the preamble.
Bill?
Well, I'm going to pick up on just what Steph just said about these being sort of these words, benefits and costs. That was my concern. How about the pros and cons? I mean, I mean, costs and benefits. I don't want anybody to think they have to do a cost benefit analysis.
Exactly.
So that's why I was worried about that language. But pros and cons would sort of make it the same idea, even if a little bit more informal.
Qualitative.
Could we say advantages or disadvantages, Bill? I think
that's fine. That's fine too. Yeah, it's probably better.
And then my suggestion would be to have a parallel edit in the preamble.
How about in deciding whether to issue a temporary rule, agencies should consider the advantages and disadvantages?
I would propose that it not be number 1, but go after the next paragraph, I think, because 2 is talking about like when they should even consider doing a temporary rule. And so it seems like first you kind of identify, is this a rule where a temporary rule might be appropriate because it's going to require annual development or whatever. And then can you scroll down, Ben? And then you could say 3, like, then you could have maybe 4, like, in considering, should consider the pros and cons. Like you could put it there as like I guess it would be the number 3, because of the first 2 seem like circumstances in which a temporary rule might be a thing. And then if you decide a temporary rule might be a thing, then it would be appropriate at that point to in deciding whether to issue a temporary rule, consider the advantages and disadvantages. That at least logically seems to flow to me. Steph?
That sounds great to me. If we do that, I think in the header, we should switch the order of the when and the whether. And then I also wanted to mention that I noticed some, I don't want to say competing because I think it's making the same point, but an alternative approach to this issue in the public comments. And so that might I just wanted to put a pin in that because I know we'll get to the public comments at some point.
Yeah. Okay. I think, does anyone have a concern with putting when and whether in the title of the recommendation here in this header, I guess? Hearing none, let's just change it to when and whether. And I guess concomitantly, anyone have any objections to the new paragraph 3, encouraging agencies to consider the advantages and disadvantages in deciding whether to issue a temporary rule? Jeff?
I guess I see the logic of putting that in number 3, but as for the heading, it does seem a little odd to say when before whether.
I think it makes sense because, you know, when it would be appropriate and then whether you should do so. Like, I think it's,
In that sense, when whether is the same issue when you put it that way. I mean, when seems to me, you know, what is a good time to do? At what point should you do it? Or
I mean, we could just say whether, determining whether to issue a
yeah,
temporary rule.
that's kind of where we started. But well, no, we started with when. Yeah, maybe whether is all we need.
Carolyn?
I was actually going to make that point. I just feel like when and whether is a little redundant, and you could just, step 1 is determining whether to issue a temporary rule. Because when suggests a temporal issue, like when and as opposed to the decision-making process of whether you need the rule.
Okay. Okay, Steph, you want to respond to that?
I think that's great. And then in line 1, I think we could also lose the when by changing that to an if.
So are we going to just get rid of when up in the top and then change the paragraph 1 to if? Is that the idea?
Yeah. Yeah, I think that's the proposal. Anyone have objections to that proposal? Okay. In paragraph 1A, I see a comment here. I think that might be from, ACUS staff changed it to finite instead of known. That seems like a perfectly good suggestion to respond to the discussion from last time. Did anyone have concerns about the word finite? Okay, hearing none. Thank you to the ACUS staff for the suggestion. I see an edit in paragraph 17, but that may be from the preamble. So I guess we can, is that in paragraph?
Yeah, it's from the preamble.
Okay, so we'll skip that and go down to.
So I'll accept this because we've agreed on that, right?
Yes. So then during meeting number 1, committee noted general concerns with the organization and complexity of paragraphs 3 through 5. ACUS staff have revised these paragraphs to simplify the text and improve readability. Jeff?
I think Carolyn was ahead of me.
Well, I think Carolyn is it's left over from her earlier comment.
Oh, okay. Well, then I want to go back to number 3 again. It's just sort of hanging there. And it's sort of an obvious statement in a way. I'm just wondering, I mean, if we should consider the advantages and disadvantages of this approach, would might help a little, but I just seems so obvious that in deciding to do anything, you should consider the advantages and disadvantages. But I get Stephanie's point that the preamble does lay out some advantages and disadvantages, but just saying what we're saying seems like a nothing burger there. That's all.
Okay, Steph, do you have a response?
I think that's a very fair point, but I will say that we have some suggestions from public commenters that I think would put a little bit of meat on the bones and articulate more clearly some of the situations in which it might or might not be appropriate. So I don't want to jump ahead, but I do think we could just put a pin in this one and tackle it with the public comments, perhaps.
That's okay with me. I mean, I just think as it is, it doesn't say anything. But if we want to put some meat on the bones later, I'm happy to try to do that.
Okay. Let's just put a pin in it, I think, and move on. Okay, so I think we can delete the comment from the staff noting that the revisions to simplify the text. Then we have a comment from Stephanie Davis. She just revised this to flow better with the preamble or with the lead clause. That makes sense to me. Does anyone have any objection to her reformulation to flow better? Jeff, do you still have your hand up from previously?
I did, but I actually know I noticed the same thing, but I was glad to see Stephanie picked up on it. And my solution was just going to be if it contemplates, but same point.
Okay, Bill?
If it contemplates.
Okay, Carolyn?
I'm sorry, I actually just want a clarification on A. Is there something missing? Explain in the preamble to the rule, including the proposed rule, if applicable. That, and I know I'm going to something you're not discussing, but I wasn't at the last meeting. Should that be including in the proposed rule?
The preamble to the proposal?
Explain in the preamble to the rule, including the proposed rule, if applicable. What do you?
Yes, I think that was intended to say including in the proposed rule. If applicable, like if there's a proposal as opposed to a direct final rule.
Right, I didn't know there was missing in there, that's all.
How about just putting, instead of including, put or?
I think we wouldn't want to say or because usually you would still include that in the final rule.
But it would be the preamble to the proposed rule.
Right, but like you would also include it in the preamble to the final rule. So it's changing the meaning there to say you would only do it in the preamble to the proposed rule.
And then put including to the proposed rule.
If you do to the proposed rule, then it implies that it's to the, well, maybe it doesn't. I think either one's fine.
Yeah, and I just wasn't sure of the original meaning of that. So I was looking at it and it, like I said, this is my first meeting. I didn't just jump out at me as clear what that meant.
Yeah, the committee added this language at the first committee meeting because they thought it was unclear that the agency whether the agency should explain in both the proposed rule and the final rule why the rule is effective for a limited period.
You could say and or the proposed rule, if applicable.
Well, I think it should probably be.
Well, not or. Yes. Yeah, not or. Okay. I think Bill had it right for the first time. Wouldn't be or, yeah.
So it would be and the proposed rule if applicable, and in the proposed rule if applicable.
Well, they would do it in the preamble to the proposed rule, not in the proposed rule.
Well,
right?
I think there was discussion in the first committee meeting about including it in the rule text if applicable. there was like
Mm.
some discussion about that for clarity's sake, that it would, be in the text of the statute as opposed to the preamble where someone might not see it.
I guess I don't remember that. I don't know why we're saying we're putting an explanation why the rule is effective, and that wouldn't necessarily be in the text that would go in the CFR. So,
but it reads now, explain in the preamble to the rule and the proposed rule if applicable.
yeah,
No, it's to the rule or to the proposed rule if applicable. It's not it's not explain in the proposed rule, it's explaining in the preamble to the proposed rule.
Well, this actually is raising an issue that we discussed in the first meeting, which I believe was whether it should go in the text of the rule or just in the preambles.
Wow.
Ben, am I misremembering that? I think we had a discussion about this, and I think there were some members who were suggesting that it should go in the text of the rule where applicable. I
can't recall that discussion very well, to be honest.
It's been a while. It's been a while for all of us. I'm fine. Like, I don't have a concern. My recollection is that there were some committee members who wanted it in the rule text,
Well,
if applicable. I am fine with it being in the preamble, but
this is the explanation. It's not the date.
yeah.
This is the why, right? The
Right.
why doesn't have to be in the actual rule. The date might have to be in the actual rule. Or
Right.
the period
okay,
might.
Bill, for clarity, I'd ask that you wait till I call on you, just so for keeping the record clear. Eyal, did you want to respond?
Yeah, according to my recollection, some committee members wanted a clarification that, or I think we also raised it, that the effective period, that the expiration date will appear in the rule text. And I think that's what we are talking about in 4C. And I think 4A is just a preamble to the rule. And the text of the rule itself, I think we addressed that in 4C. If I remember our discussion about it, because we rearranged some of the text here.
Okay. So then perhaps the answer here is to say, and to the proposed rule, which addresses Bill's concern and Carolyn's concern. Bill?
And my concern.
And Jeff's concern. Bill, are you comfortable with that?
Yes.
Okay. Anyone have any objections to changing that to and to the proposed rule? Okay, hearing none, that we can do that, and we'll go back to 4B, which the proposal on the table was if it contemplates further action to try to improve the flow from the lead clauses. Did anyone have concerns with that combined proposal from Stephanie Davis and Bill/Jeff? Hearing none, I think we can accept that. And then here's a comment from Liaison Representative Stephanie Davis, who wants to say, specify the effective period of the rule as opposed to specify the period during which the rule is effective. That seems like simpler text, but same goal. Does anyone have concerns with Stephanie's text? Hearing none, we'll accept that. Anything else? Okay. We addressed that already. So that paragraph in 10 we agreed to, Ben, so we can resolve that. Okay. So then let's go back. Let's go to the preamble. Okay. let's start with the first paragraph. Does anyone have any comments on the first paragraph?
So there was a lot of discussion at the first meeting about the footnote 1, and we revised that. I thought I dropped a comment in there on that, but maybe it's not there anymore. So, but we've revised that consistent with the committee's discussion, but they should we've left it in track changes so folks can review it.
Okay, everyone, why doesn't everyone review the track changes footnote 1, just to make sure that we're happy with it?
Again, just to remind folks, it's just we're intending that this recommendation have broad applicability to rules as defined in the APA, but noting, kind of consistent with the prior ACUS recommendations, that to the extent the agency is not issuing a rule kind of through the notice of comment process or not publishing it in the Federal Register or CFR, then they should just use the recommendations as applicable, essentially, because some of them only really apply in the case of like Federal Register publication and CFR codification.
Carolyn?
Hi, my only suggestion, just for simplification purposes, is in the very last sentence, is just to say recommendation to the extent applicable instead of they are. I just feel like that simplifies it, but I leave that out there for everyone's consideration.
I'm fine with this text. Does anyone have any objections to the ACUS staff revisions to paragraph 1 in light of the text or in light of the discussion from the last meeting? Hearing none, I think we can go ahead and accept the text in footnote 1.
I'll accept it as you guys go.
And so then let's move on to paragraph 2. And here we have an edit from Jeff Lubbers. And this is
Purely
sort
style.
of changing.
Purely style.
Okay. Does anyone have any concerns with Jeff's stylistic edit? Hearing none, I think we can adopt it. And then we had a comment from Steph Tatham. I think her comment, like in her written comments, indicated that the helping to avoid public confusion was another issue that was discussed in maybe the report, and it would be helpful to flag it here. Steph, did you have anything to add?
Yeah, I just think as drafted, the discussion of the advantages and disadvantages of temporary rulemaking focuses on the agency exclusively, but there are public benefits or advantages and disadvantages as well. And so I tried to add in these first couple of paragraphs just some examples of those. And this was one, it can help to avoid public confusion where you have a rule that remains in place, but was only intended to be temporary.
Does anyone have concerns about the language and can help to avoid public confusion? Hearing none, I think we can add that. And then here we need to kind of like see if we can see the whole, yeah, okay. A temporary rule may also give an agency the flexibility to address emergency situations or deviate temporarily from a regulatory framework while clarifying for the public that the emergency or deviation is of limited duration. I guess I don't really see the benefit of including the second emergency there. Like, I think the first reference to address emergency situations makes sense. But then, like, the point of the temporary rule is to clarify that the deviation is going to be limited. So I guess I would propose not including that. I think it's like maybe a little less clear to include the emergency twice there. But I don't know if anyone has the same reaction. Okay, Ben, would you mind deleting the second emergency or? Okay, does anyone have concerns with adding to address emergency situations or in that sentence? Hearing none, I think we can add that. That makes sense to me. Thank you, Steph, for your comment. And the next one is a new sentence at the end of the paragraph. This can promote consideration of the public interest in agency rulemaking, such as by ensuring updates to a rule to account for rapidly evolving circumstances, particularly when coupled with opportunities for public feedback. I'm finding the first clause a little like, I guess I like the way you put it a little bit in your comment better than the first clause, and I'm trying to figure out if I have a suggestion for how to change the language here. I like your point about like public comment can be a force multiplier, and it makes sense to indicate that, but
we could just say this could promote consideration of public feedback and of rapidly evolving circumstances.
Mommy. Yeah, that makes sense and is simpler.
Yeah.
And then it would be just period, right?
Yeah. Yeah. Mm.
Does anyone have comments on that addition or concerns? Hearing none, I think we can add it. Okay, the next comment, Steph said she prefers limited to scarce as some agency funding streams vary. And she's more concerned with uncertainty of future funding given events such as the recent lapse in appropriations. I think this is a good change. Must commit to expending limited resources. Does anyone have concerns with that language? Hearing none, I think we can add it. Okay. Here's another comment. This is focusing on the impact on the public of having to monitor and provide the agency with input on temporary rules. I guess one question I had is, Steph, did you have something in mind when you wanted to say public and impacted entities? Like impacted entities are part of the public.
They are part of public. That would be fine to shorten from my perspective.
Bill?
I guess I don't understand this as a con. I mean, we're talking about temporary rules versus non-temporary rules. And here, I mean, the public's going to have to expend resources to provide the agency with input on any rule. So I don't see how this is a con or a disadvantage of temporary rules. The next sentence I understand, but I don't understand how this is a disadvantage of temporary rules. It's just,
Jeff,
it's a
did you want to
disadvantage.
respond?
So I delete this sentence.
I think it could depend on the circumstance. And so, if the agency is doing a series of temporary rules, which I think is sort of implied, and maybe that's tackled in the next section, or if this is a very regular practice and there's a public input process, then there's something the public is expected to do to change the future rulemaking. And I guess maybe that's true regardless of whether or not the rule expires. But I think to the extent that the agency is updating the rule and is committing itself to updating the rule, the public will need to track and monitor that. And in your scenario, the agency may not be committing to update the rule, and they may just intend to leave the rule in place, in which case the public does not expend resources to monitor or provide feedback on that.
If I can respond, Jennifer?
Yes, please do.
It seems to me that even in a non-temporary rule, agencies and the presidents, plural, have told agencies that they have to reconsider the rules, right? So that's the reconsideration, in which presumably the public would be involved, would be again there, even if it was not a temporary rule. And I think you could explain a particular circumstance in which this might be a disadvantage, but it seems it would take too much words and be too specific to be justified in the preamble. I think the next sentence is important, but this one just is too broad, and I think it raises more questions than it answers. That's just my opinion.
I hear you, Bill, and I wonder if I could suggest, tweaking a sentence down below, and we could strike this change, because I think we're really talking about the scenario addressed in the sentence on line 23 that begins, in addition, where there are frequent changes to regulatory frameworks resulting from numerous temporary rules, and that can undermine regulatory uncertainty and could increase the costs of participation. Or I'd be comfortable with moving the idea of the increased resource expenditure to this specific scenario down below.
I like that.
So it sounds like perhaps move that sentence to be the last sentence, because we have the more frequent changes.
Well, as I understood it, we'd drop this sentence, the first sentence here.
Yeah.
And then we'd pick up the idea as one of the frequent changes may undermine regulatory certainty, make it difficult for regulators to adjust their behavior, or make long-term compliance decisions, or increase the resources the public needs to monitor the situation. Something like that.
Yeah.
I leave it to staff to wordsmith it.
So I think it probably should say and increase.
Yeah, and increase the resources the public needs to monitor. And I think, Bill, you had suggested a shorter formulation, such as the situation. But I'd like it as it is, because I think that's what the resources are being expended on. It's not just monitoring the situation, it's also participating in the process. And
Jeff?
I was going to suggest at the very end that we say such as with state, local, and tribal governments. No, in the parenthetical at the end.
Oh, let's put a pin in that because I want to address just this part first. We'll get to that
Okay,
sentence.
okay.
Does anyone have any additional thoughts on just this, the highlighted language? Stephanie Davis.
I would just suggest maybe separating that clause into its own sentence. I hate a long sentence, and this is it's a great, I completely agree with what Steph is proposing to put in. I wonder if we can put a period after decisions, an introductory sentencing, something like, moreover, it may increase the resources, and then conclude the last sentence with, finally, more frequent changes could. So that it's just
how about it may also?
Or it may also.
I don't know if you need moreover.
I think it should say such changes instead of it, because we're talking about frequent changes to regulatory framework.
May also.
Okay. Anyone have any further thoughts on that sentence? Jeff, do you have further thoughts, or is your hand just raised from before?
Oh, no.
Okay.
Do we want to just, as a stylistic change, but do we want to revise, like, instead of saying increase the resources the public needs, like, just say something like such changes may require the public to expend resources, something along those lines?
Yeah, we could do such changes may also require the public to expend greater resources to monitor. Okay. Any concerns with that sentence as drafted? I think we don't want the there, Ben. I think it's just.
I was going to say like the proceeding or something like that. Oh yeah, maybe it's parallel kind of structure. Oh yeah, that's probably fine.
Steph?
Just a minor tweak. Instead of greater, could we say additional?
Okay. Any concerns with that sentence?
Put commas after monitor and on.
So you want to insert a comma after monitor?
And after on.
All right. Anyone have any additional comments on that sentence? Hearing none, let's go ahead and accept that sentence. And then let's go back up to Steph Tatham's suggestions on the sentence beginning when agencies do not monitor their oh no, it's Jeff Flubber's comments.
No, I think Ron Levin's comment sort of superseded mine, and I agree with him.
Okay.
We're leaving in this language that I write here, correct? Still.
Yes.
Oh, I'm sorry. No, I think we haven't considered this. So some of it's Steph Tatham's and some of it's Jeff Lubbers and some is Ron Levin. So I think maybe this whole sentence we should just consider its entirety.
Yeah, let's just consider this sentence as a whole. I thought it was a, fair point that about like rules and intent and whatnot from the comment that was pre-submitted. So I like these changes. Does anyone have objections to the changes in this sentence? Hearing none, let's accept that. Okay, turning to the next sentence, this could impede agency program operations, create public confusion, and undermine predictability and competence. This is an edit proposed by Steph Tatham. Bill?
I'm just wondering what this refers to. The allowing things to expire when they don't want to, or not expire when they want them to. Is that what this?
That's how I read it. Steph?
Yes, that's how I intended it. And what I would say is it was a little hard to refer back to the entire first clause, but it is when the rules unintentionally or mistakenly expire.
Okay, all right, no problem.
Anyone have any other comments on this sentence or concerns? Bill, your hand is up. Is that from before, or do you still have a comment? Bill? Oh, no. Okay, it was from before. Okay, so let's, hearing none, let's just go ahead and accept that sentence. Okay, and this is an edit about the word numerous from Jeff Lubbers.
No, I don't think I'm not sure that was mine, but.
Oh. Well, I don't have a concern about the addition of numerous in this. It's like indicating that why there's frequent changes. Does anyone have concern with adding the word numerous? Hearing none, I think we can accept that. And then now we're going to that sentence that was a suggestion from Steph Tatham, and Jeff, you had a proposed addition to the parenthetical. State, government, something. Can you?
State, such as with state, local, and tribal governments. State, comma.
I forget, do we want to capitalize? I should know this, but
I don't.
I normally would not capitalize any of that unless there's some ACUS rule. I would just.
Okay. I think lowercase. I'm getting the bad signal for lowercase.
Yeah.
Tribal governments, right?
Yes.
Steph?
I think it's a great addition. We could add territorial, but my suggestion would be to align whatever the exact language is with the other recommendation that is being considered by a different committee on participation of state, local, tribal, and territorial governments in federal decision making.
It's a good suggestion. Maybe the ACUS staff can help with that. Just aligning with that other rulemaking. Does anyone have any objections to or concerns that they want to discuss about this sentence aside from making the note to align it with the other ACUS recommendation?
Maybe just put a footnote to that other ACUS recommendation.
I think it depends on when the recommendation comes out, probably, but like we should just use the similar kind of language. I don't know if they'll all be considered at the same plenary, but the good note for ACUS to consider.
Is it on the next plenary?
I don't know. Okay, so Steph? Sorry, what was that? For some reason I didn't hear you.
It is currently in the committee process and should be at the next plenary. Yes. Mm-hmm.
Okay.
So it could be fixed, assuming the other recommendation is approved. The footnote can be fixed at that point, I would assume. That's a question for Jeremy, I guess.
Yeah, so there is a recommendation that was adopted the last plenary session on consultation with state, local, and tribal governments. There's currently a project underway on broader forms of collaboration with state, local, tribal, and territorial governments. So we could cite to the earlier consultation one.
Steph?
I don't know if consultations are required with territorial governments, so I'm fine with state, local, and tribal. Yeah. And then citing to our earlier recommendation makes sense to me.
Great. Hearing no other comments, let's go ahead and accept that text and just the comment to the ACUS staff. Sorry, Steph, did you have a thought?
I just wanted to make a conforming edit to the beginning of this paragraph and the prior to align with our language before about advantages and disadvantages. So that says costs. Yes, we could say disadvantages in line 14. And then in the first paragraph, advantages. I'm okay with benefits. I love cost benefit analysis, but just want to be consistent.
Anyone have objections to changing to advantages and disadvantages as opposed to costs and benefits? Hearing none, let's go ahead and make those edits. Okay. Where are we next, Ben? Okay. Here. Yes. So Stephanie proposes to just start with agencies. And that seems like a perfectly fine approach because this is really detailing the circumstances as opposed to like the benefits and costs. Does anyone have concerns with that proposed edit? Hearing none, we'll go ahead and accept that. Okay, moving right along. Third paragraph, beginning with third, we have comment from liaison representative Elena Ness. Oh wait, is that later? I can't. Where is that comment? Oh yeah, okay. Deviation right. Is a term with meaning within Coast Guard regulations, specifically related to drawbridge operations. So we would prefer it not be used out of context. Additionally, nearly all Coast Guard temporary rules establish new temporary regulations rather than amend existing ones, which may be more common for other agencies. So she proposes changing this from agencies use temporary rules to permit deviations from an existing regulatory framework to establish or amend. But then I think we do need an article like to establish or amend a regulatory framework for a limited period. Bill?
I was going to make that same comment.
Okay. Does anyone have a concern with making the change to that sentence to establish or amend? Jeff?
Just that I think we use the term deviation in the recommendation itself later on. So.
It looks like we do not. So I think
there's a reference to deviations for we're citing Office of Federal Register regulation, but I think that's fairly clear that that's distinct.
Okay, so any objections to establish or amend that change to that sentence? Okay, let's go ahead and make that change. And then she had a further comment. Regulated navigation areas are rarely temporary, but our special local regulations often are. So we suggest replacing that reference. Unless there's a Coast Guard specialist on the call, I suggest we defer to Elena on that. And then
Elena does have an alternate here if they want to speak up.
Okay, and line 34. Sorry, Dale.
No objection. I agree with her recommendation there.
Okay, and we suggest removing other from other unsafe conditions since it implies the rest of the list may also be unsafe. And that does make sense. We don't want to suggest firework displays are necessarily unsafe. That would be so un-American. So other occurrences.
And that was just to clarify, that was a Jeff Lover's suggestion. Give credit where credit's due.
Maybe, yeah, I guess I'm fine with that change. Does anyone have, can I see Elena's comment again real quick?
Yeah, sure.
Sorry,
Hold on one second. I think I can she may have also had a suggestion there, but
she suggested removing the word other, where it would just say.
Oh yeah, sorry, maybe I missed that. Sorry. And I guess it raised the question about if because Jeff had a kind of competing or.
Okay, Jeff, what are your thoughts on removing the word other in front of occurrences that might pose a safety concern?
I guess it's okay. Well, and occurrences. I mean, I think the ones that are listed might pose a safety concern. They're certainly not inherently unsafe, but I guess I'd leave the word other in there because I think those do pose a safety concern.
Dale?
And maybe some other things that we haven't thought of.
Yeah, I think I agree. We typically, most of these things are safety zones, and we put them up because of safety concerns. And even marine events, which are special local regulations, we usually do that because there's an unusual concern about safety. So I think I agree with that.
I think that by changing it to occurrences that might pose a safety concern, that minimizes some of the concerns she had about other unsafe conditions. So we can probably keep other than. It's just saying they might instead of saying that they are. So yeah. Does anyone have a concern with this language now as drafted and other occurrences that might pose a safety concern? Hearing none, I think we can resolve Elena's comment and Jeff's comment and add that language. Okay, now paragraph 4. Okay, so Jeff's comment is here that agencies may, as a means of committing to retrospective review, is really distinct from regulatory learning.
Well, we say that there are at least 5 circumstances in which agencies use temporary rules, and we list 5, but this sentence seems to me to be a 6th. I mean, it's a separate. I don't feel strongly about it. It's just it seems to be a separate situation where they might want to do it, and so we have 6 circumstances, not 5.
I agree with Jeff. I just think we ought to break it out, make them 6 examples, and this be the 5th.
Steph?
We do have 6 down in the recommendation, so I think 6 makes sense. We've got A through D, and then we have in one recommendation, the next recommendation, we have 2 additional.
Okay. Oh, I see what you're mentioning. Okay.
You just wanted to point out that the way that the recommendation is structured includes retrospective review in this concept of regulatory learning. So if we change it in the preamble, we probably want to change the recommendation as well.
Bill?
In that case, I take back my comment that we should make it a separate one because I don't want to mess around with the recommendations and it's not that important.
Okay. Jeff, how strongly do you feel about
I
mentioning
don't,
that
but
we should-
maybe the sentence could be just said, you know, if we're going to leave it in the fourth example, have some sort of transitional word or two in there, like as part of their learning, you know, agencies. I don't know. It wasn't obvious to me that this was related to regulatory learning, but if anybody has a suggestion to make it clearer.
I have a suggestion, which would be rather than adding that new language here, moving the fourth to the second sentence and then but I am still, I guess I am confused by the numbering altogether now because we're at 4 here, but in recommendation 2, we have 4 already, and then 3, we have 2 more. So this might be a committee on style issue, but the easiest thing might be to just delete the count altogether.
Well, how about adding, make the first sentence in the in that paragraph beginning fourth, agencies use temporary rules as a vehicle for regulatory learning and for committing to retrospective review of rules.
Well, I think the point that Ben already made is technically in the rule, in the recommendation, we capture both as part of regulatory learning. Like in the sort of lead in to those two examples, it talks about it as regulatory learning. So
I don't know if you want to say including committing to retrospective review, but if you do that, then you maybe need to remove that other sentence, and then it has a footnote that has content that we'll get to.
honestly, I'd be inclined just not to mess around with it and to just leave it as is. Does anyone feel strongly besides Jeff about breaking out the retrospective review as a new one?
To me, retrospective review is a more well understood thing that agencies do. It's required by executive order that agencies do it. And the idea of regulatory learning is sort of a more amorphous concept that ACUS has helped to develop, but it's not what agencies think about first here. They think about, oh, we have to do retrospective review. They don't think, oh, we better do some regulatory learning. So it seems to me that it's sort of the cart before the horse here a little bit. Retrospective review is a more important concept in administrative law, more well understood and the kind of required concept in administrative law. Regulatory learning is sort of a aspirational thing.
Dale?
I'm just wondering if this is intended to refer to temporary final rules. I mean, sorry, interim final rules. I mean, they're called final rules, but they're really temporary. They're supposed to be superseded by a real final rule. And I'm wondering if that's what this is really all about.
That opens up another can of worms that we dealt with in another recommendation. So,
okay, I just thought I'd raise the point.
Okay.
But I don't know if does anybody, if we switch the two concepts and said fourth, agencies use temporary rules as a means for committing to retrospective review of those rules, and then say in the second in the next sentence that they and other means of regulatory learning or something like that? Because to me, the retros, I'm not going to repeat what I just said, but it's
Steph?
I wonder if we could just say agencies use temporary rules as a vehicle for regulatory learning and retrospective review.
Well, this goes
And
back to the
then-
point that we're in the rule. We'll have to change the text of the rule because the introductory clause captions this as part of regulatory learning.
No, I don't know. Not.
No.
Some references to our earlier recommendations on retrospective review. And I pulled these from the really helpful synthesis that the staff put together. But recommendation 2017.6 -6 is called Learning from Regulatory Experience. And so, we have considered that as part of our body of work on retrospective review, and we reference it below.
Bill?
I'd go back and ask Jeff. He originally said he didn't feel that strongly about it. We spent a lot of time on just fiddling with this language. I suggest we go back to the original language.
all right, Bill. If I don't have you as an ally, I guess I'm not going to win. So
Okay. Let's go ahead and go back to the original and mark this comment as resolved and move on to the next text.
And yeah, I'll delete this. We're not going to use this language, right?
Right.
Yeah. Oops.
Just go back to the original. Okay. And then this is okay, so footnote 9, ACUS staff has added a new example to footnote 9, consistent with discussions at meeting number 1, and removed one of the existing examples to manage the length of the footnote.
And this does kind of interact with some of Steph's comments, but that was the first one.
Does anyone have concerns with the ACUS staff additions to footnote 9? Steph?
Oh, sorry, the addition is welcome. No concerns with that.
Okay. Hearing no objections, let's make those changes. Make that additional. Okay. And then I guess also in paragraph 9, you deleted the HHS example. Does anyone have concerns about the mention of the HHS example and its withdrawal, the deletion of that in footnote 9? Hearing none, let's accept that deletion then too. Okay. And now Steph proposed taking 2 sentences from footnote 9 and putting them in a new footnote 11 and making, or I guess a new footnote.
Yeah, it might be best just to consider. So Steph had, yeah, she inserted these 2 sentences and then added 2 new footnotes. And then the footnote 11 incorporates some of the content from existing footnote 9. I don't know.
Okay. Steph, did you have comments?
Yeah, and maybe we could treat these separately. We had discussed in the last meeting that ACUS does have several recommendations about retrospective review. So leaving aside all of the footnote stuff, I just thought it would be good to reference them. And so I added some language stating what ACUS stated and including a footnote citation to those recommendations. And I would, of course, defer to the conference staff and committee on style and the particulars of whether I've done this properly. It's been a while since I was a staff counsel.
I have no objections to this addition. Does anyone have concerns with Steph's proposed addition referring to ACUS recommendations on retrospective review? Bill?
I don't have objections to the substance, but it just seems a little bit far afield from talking about temporary rules. and whether and when to use them and the best practices in using it. It's just sort of it seems to me a footnote material, but because it's just doesn't relate to temporary rules per se. I mean, ACUS has done these things, they're good things, we agree with them, but it just seems like sort of by the by here.
Steph?
I'd be okay not to include it. Part of why I did suggest including it is because the footnote 9 still has that second sentence referring to the broad scale sort of sunsetting, which, is an area that we haven't really examined much, but might benefit from some consideration of our prior recommendations on retrospective review. But I'd be okay to delete it. I would still like to move the next sentence though, and I think part of why it's valuable here is the language in the footnote that we might end up getting into.
Okay, should we look at footnote 11, I guess? No. Because it sounds like
go
that's
ahead and so are we gonna delete this sentence then, the first sentence?
It sounds like she's comfortable with deleting it.
And then we can move on to the second sentence, which then contains now what's footnote 11 is now footnote 10.
Well, I don't think the sentence by itself makes sense without the previous one.
Oh yeah.
But footnote 10.
Why don't we put that language in the footnote? Right after the citation of those orders.
I'll put the sentence back just for clarity.
Not that sentence. Not
I know.
yeah. The previous the however sentence.
Well, Ben, I might propose taking that sentence about several recommendations and putting it in what is now footnote 11.
Okay, so
and taking what is footnote 10, those citations, and putting them in that same footnote.
So just to clarify, what should I do with this initial sentence?
That should go in the footnote with the stuff about President Trump's sunset, or like ACUS not like that can all go in, be condensed to put into a single footnote. ACUS has said this, cite the recommendations. ACUS has not yet broadly addressed.
So we're putting it into this
footnote 11. Yeah. And then footnote 10.
Or to do it afterward.
No, yeah, like I would put it first.
Okay, first.
And then put footnote 10.
And we'll
right
put
after
these sites. We'll put these sites
site.
in the like this.
Then you put the sentence, however, the conference has not addressed.
And then that, sorry, that
in the footnote.
Okay. And then
before the words President Trump.
And then the only question is, where do we put the footnote itself?
Yes, that is a question. I mean, we could put it up. Let's see.
The however goes at the very end.
We could put it right after retrospective review, like just put the footnote right after before the rules, and then the examples follow the agency.
But the general idea is that we would just have the sentence, agencies may promulgate temporary rules and means of committing to retrospective review. Then we still have this footnote 9 by itself. And then somehow we need to figure out how to get footnote 10 by itself with all this content that used to predominantly be in the body of the text.
Yes, that is what I would propose.
Okay. So there's a stylistic matter. We can at least consider that if we can't get to it here.
Steph, what do you think about that? Sorry, Steph, I think you're muted and I can't hear you.
Apologies. Yeah, so we have the zero-based regulatory budgeting EO now in 2. It's in both 9 and 10. So I think we should just strike it in 9 and then move all of 10 to after 1985 period.
Oh, combine them into a single footnote?
Yeah. And then I still am okay if Bill prefers to drop the ACUS endorsement of recommendation review and the however, if we're looking to save space in this footnote, we could just say the conference has not addressed and then have the subsequent citations, but I'm happy either way.
Jeff?
I'm not sure exactly what it's supposed to look like now, but I th in the green number 10 now, I think what I would do is take out the word, well, are we going to have that stuff at the event to ensure periodic record? The HHS example, we're not going to have that anymore, are we?
Well, I think Stephanie's proposal, then, if you want to do this, is to just move everything that's in 10 up to the end of footnote 9 and then cut.
Okay, let's see how it actually looks.
So add this all to footnote 9.
Yes.
And then cut the sentence President Trump recently directed agencies from footnote 9. So it goes from straight from like December 6, 1985. No, earlier in the
Sorry.
footnote 9 has the exact same text.
Oh, got it. Sorry. Yeah.
That sentence there. So it goes from the Social Security Administration example, then to ACUS has issued several recommendations.
Right.
That was Stephanie's proposal to combine the two.
And then I'm fine deleting the last sentence to ensure periodic retrospective review. I'm totally fine to delete that. I'd also be okay, depending on how, if Bill still feels strongly to delete the retrospective review example.
Okay, I don't have any concerns with deleting the example from HHS there. And Jeff, what are your thoughts?
My thoughts were, I agree with deleting that. So, but then I would move the statement that, where is it? The however sentence after those executive, that sentence to the end. And I think I would take out the word however, I would just say the conference. Yeah, I think that's the way I would do it.
I'm fine with that. Steph, did you have any concerns with that approach?
I do not have any concerns. I do want to hold space though for the public comments on this point. So hopefully we'll get to that. But yeah, this footnote's doing a lot of work, but it looks good to me. I have no concern.
Do you want to maybe insert an also after here, because it's kind of separate. We're basically saying like, there's the SSA example. We're saying what ACUS has said, and we're saying what President Trump recently did, and then we're saying the conference is not addressed. So put an also here, just to designate their separate points.
Okay, any objections to the footnote as currently?
I don't think we need the word also. I mean, I think that makes it, he's the president, we're ACUS. I would just say, yeah. And it's recent. It's after these recommendations that we're just citing. So I don't think we need also there.
Okay, any objections to the footnote as presently comprised? Okay, we'll accept that footnote. I think that's resolved. Okay, can you scroll down and see what's next? Okay. There was a suggested edit to footnote 15 from senior fellow Amy Bunk, which seems sensible to me. Any objections to changing how we discuss the printed CFR? Hearing that, I think we can accept that change. Okay, Ben, correct me, but I think that's all that resolves all of the comments from ACUS members.
I believe so. We'll just scroll back through to make sure. I don't see anything else. And
okay, so I would propose then that we take a 5-minute break, and then we'll come back and I will call on, with consent of the committee, I will call on the public commenter to make any oral comments in addition to what they already submitted. Potentially highlighting anything that they feel particularly strongly that we should consider as a committee to the rule at this point, now seeing the sort of text as it stands. So Ben, what do you think? We can come back at like 2:53, whatever 5 minutes from now is.
250, yeah, 2:54.
Okay. See you then. Okay, so is someone on the line from the member of the public who sent an advance comment in?
Yes. Hi, Jennifer. This is Jason Schwartz from the Institute for Policy Integrity.
Great. Can you go ahead and give us, I guess, a summary of what your comment is and what you'd like us to consider?
Absolutely. So thanks so much, Jennifer. And I'd like to start by thanking and commending the committee and the ACUS staff for developing these recommendations on such a topical issue. For those who aren't familiar with Policy Integrity, we're a nonpartisan think tank based at NYU School of Law. We focus on issues of administrative law as well as environmental and energy policy and economics. I personally have also served as a consultant to 2 prior ACUS projects. So we love trying to work with ACUS whenever we can. Can I ask, would you like me to make all of my comments at once or sort of go recommendation by recommendation?
I think just an overview of your comments would be helpful.
Sure. Okay. So I'll start, if I may, with some thoughts on recommendations 9 through 11 before circling back to some thoughts on, or sorry, I should say what were recommendations 9 through 11. I forget the new numbering now. And then I'll circle back to some of the other issues that we've touched on. So in what was at least recommendation 9, which was on a process and public comment during the extension of a temporary rule. Appreciate some of the edits made today to really try to clarify that taking public comment is the default requirement when it comes to an exception. I would still recommend fleshing out some additional details there for at least 2 reasons. One is that when we're talking about the extension of a temporary rule, or sometimes the multiple extensions of a temporary rule, the case for good cause for skipping public engagement really should start to shrink. The agency has had notice and time to deal with any emergencies. I think additional encouragement to the agencies on how they can actually undertake public engagement even when they're perhaps have good reason to not do a formal comment period, there's still a lot of opportunities during the period of the temporary rule or preceding any extension to use other strategies that ACUS has laid out before. And it's terrific that, and this is sort of the second reason for more details, it's terrific that ACUS refers to the 2024 recommendation. That recommendation actually cross-references a 2018 recommendation. Now you're kind of counting on agencies to go 3 layers deep to figure out what they should do. So what we've suggested in our comments, we've really just taken those earlier sets of recommendations and pulled some of the key material up here to make it easier for agencies and others to, see what they should actually do rather than have to go through 2 different cross-references and try to piece it all together themselves. This language could probably be shortened, but these were some of the key ideas that we thought would help agencies, suggesting things like requests for information, more targeted outreach, using online forums, et cetera. In recommendation 10, again, since we're talking about the context of an extension of a temporary rule, it seems like a good opportunity to encourage the agency to do some of the things that they may have, for good cause, skipped in the original promulgation because of an emergency or other circumstances. And so it might be helpful to remind the agency, again, if they collected any public comments or otherwise engaged with the public, they should consider that. If they haven't, they should do that and then consider that in assessing the extension. And also, if it's the type of rule where it would have been appropriate to assess the costs and benefits, that's something that they should take at least some extra time to do, especially if they didn't assess the costs and benefits originally for the original temporary rule. They should do that for the extension. But even if they had, the extension might have just looked at a very short temporary period. Now we're talking about, the original rule might have looked at a temporary period. Now we're talking about an extension, possibly multiple, successive extensions, and the costs and benefits of all those effects should be considered. Moving to recommendation 11, this seems like a really good opportunity to encourage agencies to be more transparent when they can about their temporary rules. Again, this might not be appropriate for all agencies, but it's something that could be really beneficial for at least some agencies. And apologies, I know all my numberings are off. This is not, number 11 now. I guess it's number 12. So we suggest some language, encouraging agencies to at least consider procedures that could increase transparency around their use of temporary rules, disclosing the rules in an online database, ideally also listing things like the duration of those rules, and if comments were originally taken or not. Returning now to the beginning of the set of recommendations and to what has now become recommendations 1, 2, and 3. Really appreciate the suggestion that Steph made on adding the language about the advantages and disadvantages. I agree with Steph entirely that the preamble and the report do a wonderful job of going through all those advantages and disadvantages. I would just say, and as much as it pains me a bit to say as a former ACUS consultant, that not everybody's going to read the preamble, and especially not everybody's going to read the report. I do think those things are true. And so it's really valuable to get the material into the recommendations themselves. And so, I would flesh out that list of advantages and disadvantages In our written comments, really all we've done is pulled up the factors that were laid out in the preamble and in the report, and listed them out. We do suggest a bit of a broader reorganization of these, early recommendations. I happen to think that, you know, the reorganization we suggest would work a little better than what is in the draft, but I do think that some of our suggestions would be compatible with the structure you have now. Some of the other things we suggest besides, detailing out the advantages and disadvantages, or really, just as we say, considering various factors to determine whether it's appropriate. Um, you know, I also think it's helpful to encourage agencies to consider the optimal duration of their rules. That could be making a rule permanent, it could be making a rule temporary, and then it's deciding how long, if it's a temporary rule, what is the actual optimal duration. Um, we also have sort of combined some of those additional examples that are in recommendation 2. When Steph was trying to count, like, what are the 6 different things, there are 2 of them that are kind of in recommendation 2. We've actually suggested collapsing that back into, just one list of all of the factors and sort of considerations to consider in assessing whether a temporary rule is appropriate. Um, I think that structure has the added advantage of, there was some discussion during your first meeting on whether some of the language in recommendation 2B perhaps inadvertently suggested implicit approval of um, a certain kind of retrospective review sunset kind of structure. I think the edits that were made during the first meeting helped address that, but our reorganization kind of avoids the problem altogether. So, I would, suggest that you consider our reorganization of those recommendations. We also add in an example that is hinted at in the preamble, but not explicitly listed out, which is the usefulness of temporary regulations in the context of uncertainty, especially in cases like new technologies, where there's so much uncertainty that it makes sense to kind of take baby steps. Um, the last thing I'll mention from our comments, this goes largely to the discussion around footnote 9. I do think with the edits that Steph suggested, that's gone part of the way to address our concern with some of the language here. I would suggest just taking out the example of the zero-based executive order. I think it's a bit of a confusing example because, though it is true that part of the order refers to building sunsets into new rules and perhaps trying to use it as a way of experimentation, that is not the main thrust of the executive order. I don't think that's what the public thinks about when thinking about the executive order. And I'm not editorializing here. By sort of its own language, the executive order is most focused on phasing out what it sees as outdated regulations. And so I don't think it's a great example of using temporary rules for regulatory learning. I think it's really, a different, has a very different focus. And I'm not sure, what the example adds, especially because bringing it up requires this caveat of saying that ACUS is not taking a position on sunsets. I think it would just be easier to cut the example completely. And those were our comments. So I really appreciate the chance to offer these thoughts. and would be happy to answer any questions anyone might have if you're interested in considering some of these changes.
Okay. So does any committee member want to, or any ACUS member, I guess I should say, not just committee member, want to propose that we look specifically? There were a lot of comments here. And we obviously there's a lot of water under the bridge considering all the ACUS comments. So of the comments submitted by the policy integrity group, is there one in particular that an ACUS member would like to propose that we consider currently? Steph?
If we could go down to recommendation 3 or 4, I also have lost track of the numbering. But, we did put a pin on that question of whether to articulate this more clearly. And there were some considerations, I think, offered by the Institute for Policy Integrity that could be helpful. But they mostly weighed on, I'm not sure they were all disadvantages or advantages, so I'm not sure the language is exactly right. So they said agencies should consider a variety of factors when determining whether it is appropriate to designate a rule as temporary, including whether doing so would increase efficiency by combining issuance and repeal. So I feel like it is a little bit hard to get into the specifics of a list because do we have to clarify if it's an advantage or a disadvantage? But I know that, Jeff, you had some concerns about keeping this without having any specifics.
Yes.
Yeah. So I think it's helpful to keep this and to have some articulation of what the advantages and disadvantages might be. And I think the policy integrity language provides that, but it's not quite a perfect fit. I also recognize that it's a lot to reopen this. And so, Jason, I guess a question that I might ask you is if you think that the factors that you all articulated are adequately covered in the preamble, or if there's something new that we should contribute to this discussion.
Jason?
I do think they're largely covered in the preamble. I stand by my suggestion that not everybody will read the preamble even. And so I think it's useful to lay out the factors in the recommendations themselves. I know that ACUS has done that in other sets of recommendations, has sort of laid out factors or advantages or disadvantages or whatever the language may be. I think everything that we suggest in our list could be rewritten to make it more compatible with advantages and disadvantages, or that language could be changed to say the agency should consider various factors, including, and then have the list.
Bill, is your comment on Steph's proposal or is it on something else?
Oh, it's on Steph's proposal specifically. Independently, I was going to make exactly the same comment she made. And I don't know what the proper thing is, but I'd move that we would add to paragraph 3 here, the language that's in, I guess it's section number 4 of the Policy Institute's recommendations, page 5 of it, A through F. I wouldn't include G because I think that's a different concept. But I'd say A through F. I move adding those to our recommendation 3.
Ben, do you want to?
Yeah, I can bring it up pretty quickly. I got it kind of semi-copied and pasted here, and I can bring it up in just 10 seconds. I'm just copying from the PDF, so just give me 1 sec.
And Jason, this is not because you cited to some article I wrote in one of your footnotes. I'm not. Flattery won't get you
Well,
that far.
I'll give all credit to our students for that. We worked on this as part of we teach a clinic at the law school, and so our clinic students worked on this project. So they found your excellent article.
Steph, did you have something to say?
The formatting won't be great, but this is A through G from pages 4 to 5 of the policy integrity comment.
I
had suggested A through F, but
yeah, no, or I'm sorry, A through F, sorry. And then the G was okay, I'll remove that for now.
Okay, so I agree with A through F. I would just change our existing chapeau a bit. So maybe consider the advantages and disadvantages. I'm fine with factors. That might be better. Should consider factors, including.
Yeah, I had intended that my thing would include the introductory sentence that says agencies, whether it is appropriate, consider a variety of facts and determine whether it's appropriate, including.
Give it to me one more time, sorry.
Just add including at the end. Comma, including.
It's possible I cut something off without. Oh, maybe not.
I think Bill's suggestion is maybe to include the chapeau, or like change that introductory sentence to say, should consider a variety of factors. Because this isn't really written as advantages and disadvantages, comma, including, and then instead of the advantages and disadvantages.
Friendly amendment, thank you.
Ayal?
I think that the language suggested in the public comment might be a bit better, just because it's not deciding whether to issue a temporary rule, but it's whether to designate a rule as temporary. I think that's the issue that we're discussing here. So the language might be, I think the important thing is whether to designate the rule as temporary, because we're not discussing whether the rule should be issued at all.
Okay.
Would it be to whether to designate a rule as temporary?
Yes, that's what Ayal suggesting. I would probably, in paragraph B, delete either temporarily or for a limited amount of time, because I think that's redundant to deviate temporarily from a regulated framework. And then I'd probably say such instead of, for example, such as with pilot or demonstration projects. And then I think we're missing E in front of the possibility.
Yeah, I'll reformat afterward too.
And then we need the word and before F.
We have to worry about the Ron Levin problem on E, that rules don't expire on their own.
And then we'll need a pair of, yeah, so.
Yeah, and I can update it with the language that corresponds to what we changed that to.
Okay.
I can try to do it on the fly, but I want to move away from the language.
And then we'll need a period instead of a semicolon at the end there. Okay. Does anyone have comments on this edition? Does anyone have, it sounds like Steph and Bill were in favor of this edition. Is anyone opposed to this edition? Okay, hearing no opposition, I think we can go ahead and include that language. And then I would ask if anyone has any other looking to the comments submitted by Public Integrity, whether there are any other comments that people would like to move that we consider as part of this draft. Jeff?
Going back to that footnote in that executive order, I did think it was a point worth considering that the executive order 14270 there. I think we've characterized it accurately. I think a lot of people do think of it as kind of a sunset order with respect to those certain agencies, but it does kind of unnecessarily put ACUS out there as saying, well, we haven't addressed this important question. So I guess I'm just kind of sympathetic to the idea of maybe taking it out just because why does ACUS need to say that we haven't done something? I mean, maybe we should have a project on it, but to say that, I guess the argument for it is, it is out there and it's related, but the argument against it is we're sort of a little bit of a self-inflicted scratch, I would say, for ACUS. It's just to have to put that in. So I'm just raising it because I'm sympathetic to the point. I'm not a member of the committee, though.
I don't have any concerns because it's an accurate description of something he recently directed to do. I think the sentences are different enough that we're not suggesting we are taking a position on that executive order because it's talking about directing certain agencies. And we say the question of broadly using sunset mechanisms. So it's not like we're criticizing, we're not endorsing, we're just saying he did it.
Right.
So I'm fine with it as is, but Bill, it looks like you have a comment.
I'm with you, Jennifer. I think if we keep the sentence that starts with President Trump, I think saying that the conference hasn't addressed it is a way of indicating that we are neither criticizing it nor supporting it. We just haven't addressed it. And the fact that it happened in April, the fact that we haven't addressed it is, hardly surprising. So I don't see that it's a scratch or anything bad to the conference. And I think it does, if we keep the sentence on President Trump in this sunset provision, then I think keeping the conference's position is pretty important.
No, I agree with that. I just was wondering whether we needed to keep the whole reference.
Well, my original position was I thought all of this was sort of not really related directly to temporary rules, but I also felt that as long as it was in a footnote, I didn't care that much.
There are a lot of important footnotes, Bill.
I'm hearing no serious, I'm hearing let's consider, but no one is strongly. Jeff Tosi, sorry, did you have a comment?
Yeah, can you hear me now? Am I?
Yes.
Yes.
I'm just wondering whether that last paragraph, however meritorious, really adds anything to the process, given how different audiences will be reading that with different sets of glasses. So I'm not sure with the uncertainty related to some interpretations of that, that's not necessarily the benefits exceed the costs. But I don't feel strongly, it's just my view on that. Thank you.
I mean, we could just delete the two sentences, President Trump and the conference, but then we've
I
left
think
it
that
as,
I think that would be I think that'd be a great step forward.
okay.
I certainly
Does
don't have
anyone-
any, I certainly don't have any objection to it.
I would support that.
Okay. Steph?
I'm also comfortable with that, but I would like to request that we be prepared at the plenary session with that language, just to note, you know, in the event that it does come up, given that some of these initiatives may be addressed through temporary rules, that we be prepared with that language, which came directly from the consultant's report, and I thought was very well stated.
Okay. Ben, is anyone opposed to deleting those two sentences? Hearing none, Ben, I think we can delete them. Okay. Anything else from the policy integrity comments that an ACUS member would like to propose we consider? Bill?
I was sympathetic to the idea that our reference in, I don't remember which recommendation it is now, to the executive order, which apparently then incorporates another executive order, and whether or not either that other executive order should be specifically called out in our recommendation, or in some way what the Policy Integrity Institute has done on its page 3, where it has sort of, I guess, either summarized or spelled out what it says. Ben, can you take us to the recommendation that includes the reference
Yeah, so was this
to
the one on recommendation, what was then recommendation 9, I guess now 10? Was that?
Yeah, recommendation 9 or 10, yeah. Yeah, 10 now. So I mean, I would be, it seems to me it would be nice if we could make a specific reference to the recommendation 218.7, as well as this one. Public input on the rule identified in that one and the other one. I'd be settled for that rather than get so wordy as to try to include these things, which that would be an alternative. But I think just at least calling out that other other recommendation would be worthwhile.
Yeah, I think my preference would be to just add a citation to the other one as opposed to trying to summarize, because I always worry that we're not fully capturing a previous recommendation if we're summarizing two of them. So I think just a citation to the additional recommendation would make sense.
Yeah, so we can add that as we can do it on the fly here, or we're happy to add it after the meeting.
Jeff?
Would it be out of order to ask Jason if there's any other specific language change that we haven't dealt with that he wanted to reemphasize, since we're now kind of wordsmithing a little bit?
You're going to ask him to kill his children? Which of his recommendations?
Pick from among his children, yeah.
Jason, do you have a favorite child that you feel that we should consider?
And we're talking specifically about here in what's now recommendation 10.
No, I think
No,
we're
no,
talking
anywhere.
in general. In general.
Anywhere. Okay, anywhere. I mean, I really appreciate the careful thought you've given to our comments so far. I mean, I think we knew that our suggestion on the what's now recommendation 11 on encouraging agencies to consider costs and benefits was probably a bit of a stretch. I do think the mentioning something about transparency around temporary rules in the internal policy section might be worth considering, even if it's not a separate recommendation or a separate, bullet there. The word transparency might be useful.
It says it in a paragraph leading. Policy which should be made available to relevant agency personnel and the public. So it's pretty
Sorry,
transparent.
I didn't mean a transparency of the policy, but transparency around the agency's overall approach, like it really in the sense of having some kind of a database of their temporary rules.
Rebecca, I think I saw your hand go up first.
Right. Thank you. When I read that comment, I had some confusion about where is the lack of transparency? I mean, these are public rules that you can look up in the CFR. They're marked temporary. What is the concern that they're not transparent?
Absolutely. I think what is hard for the public to track is the number of times a temporary rule might be extended or the overall pattern of an agency relying on temporary rules in a certain subject area, perhaps especially temporary rules that might bypass public comment, and sort of the aggregation of all of those over time. It's very similar to concerns that have been raised about agencies' use of guidance documents and calls for increased transparency. Of course, those are all open to the public. You can find them somewhere, but until they're all cataloged together, it can be hard for the public to understand, the overall scope of the use.
My concern with this suggestion when I read it in the comments was like the Coast Guard, which is issuing tons of these like temporary rules for special
Sure.
units around that. To me, that strikes me as like very burdensome for an agency and not really that I did not see the benefit of transparency for that. Like I think given that they are published, but I see Amy Bunk raised her hand. So Amy.
Sorry, I'll turn my camera on. Since Miriam's not here, I feel I should probably jump in. Amy Bunk, senior fellow. The Federal Register, if the temporary rule is extending an earlier temporary rule in the date section of that extension document, agencies are required to list the Federal Register sites for the previous temporary rules. So if you search on the Federal Register and you pull up the document, you should get all of the temporary rules. And the most recent one will include citations to the earlier ones if they didn't come up in your site or if you missed them. Thanks.
Bill?
Well, Jason, I'm sorry, but it seems like this would be what you're suggesting would be useful to an academic who wants to do a ACUS study. But it's the public, period. The public, I don't think they're interested in these statistics. Congress can always require an agency to provide it with it if it wants it. And I do see that it could be burdensome or not even that burdensome, but I can't support this one.
Does any ACUS member want us to consider adding it? Hearing none, I think we can view that one as rejected. I think we're getting close to being able to vote on this recommendation. Before I proceed to sort of voting procedures, Is there anything any other ACUS member wanted us to consider adding to this preamble or recommendation text before we move to a vote? Okay, I'm hearing nothing. Let me pull up my handy dandy instructions from ACUS as to the script for voting. So I do this right. Okay. I think, I guess we probably don't need a voice vote. Let's just ask for a show of hands using the raise hand feature. All in favor of approving this recommendation to send to the plenary, please use the reactions button to raise your hand in favor. And again, only members of the committee should vote. And please keep your hand raised while the...
Yeah, I'll tell them. Any other ACUS staff on the line if they want to count to make sure I do it right.
Okay, Ben, let me know when you've counted and then I'll instruct you.
I feel like that's sufficient, but I'll just to... Let me just make sure, Dale, you can vote if you want, but just letting you know, I'm not telling you how to vote, but because I believe Elena is on the committee, unless I'm mistaken.
That I wasn't sure about that. I would
Yeah.
be in favor, you know, if we can vote, but I was thinking we were a non-voting member.
Since you're on the committee, and Jeremy can correct me if I'm wrong, but I think as long as you're on the committee, which you are, you can vote, and Jeremy can weigh in.
That's correct.
Okay.
So I think that was the only person that I saw. I don't know. So Dale, did you want to vote at this round? Did you want to vote yay?
Yeah, he's raising his hand. Okay.
Yeah, I think
everybody
I got 9,
should lower their hands. And now, if any member of the committee wants to vote against the recommendation, please raise your hand now.
I see no hands raised.
Okay, great. Thank you so much for everyone's hard work on this. Thank you to Al, Ben, Jeremy, Jeff. I see you have your hand raised. Do you have a comment?
I do have a comment. I just wanted to give you kudos for running a great two great committee meetings, and managing to get this out in 2 committee meetings is not easy. So great job.
It's too bad we couldn't have 2 or 3 more.
Bill, did you have a comment as well?
Yeah, I wanted to second Jeff's comments, but I also wanted to thank the Policy Integrity Institute for taking the time, the effort to weigh in on this, and I think it helped.
Great. Yes, thank you to the Policy Integrity Group for their comment. Thank you to the ACUS staff, all the committee members for their hard work. I think with that, we are adjourned. Ben, correct me if there's anything else.
I think that's right. Yeah. So we'll again, we have some just stylistic edits to make, but we'll circle back with the committee shortly with the final version that incorporates any stylistic or editorial edits that we need to make.
Okay, great. Thank you so much, everyone. Have a good holiday season.
Thank you.
Thank you.